Mount Waverley.
Thank you, Acting Speaker. And I rise to speak on the Justice Legislation Miscellaneous Bill 2019. And I would like to just start by just mentioning a couple of my colleagues who mentioned a few things I'd like to point out. Firstly, the member for Frankston, I don't think I've ever heard "Better Call Saul" said in Parliament before, so that was a nice little thing. And his comments on a recent amendment that is before us, I believe, were summed up, I think, if I can paraphrase, by it being more of an unreasonable amendment. He also spoke about the wages that were stolen from Indigenous Australians in Queensland. I think we're seeing more and more companies coming out in the news. I think there's even one today who I won't name, but with sort of putting themselves out there that they have not paid people what they should have paid people. I can only imagine that they are doing this on the basis that they know that there are wage theft laws coming, and they're probably better off saying it now. So this is something our government's committed to, and I think these changes in regard to our class action laws are part of what will hopefully mean our big corporations act in a more dutiful and better way, so they're actually paying their staff proper amounts. I also will point out my good colleague and neighbour, the member for Burwood, pointed out that the member for Uplands Valley seemed to comment on a diverse range of views, I think was the statement, and I guess go figure. This is the House for a diverse range of views, so that's not a particular surprise. And I must admit, most of the time when we wait for the members on the other side to stand, we sort of know, really, you get a sense that you know already what they're going to say. And I think the member for Bill and I coined the phrase before, it's sort of like pre-ja vu. So, I think the cornerstone of our legal system is that every person has a fair and open access to seek the justice that they deserve. But lawyers are expensive, and very experienced lawyers are very expensive. We don't all have a retired QC who comes and knocks on our door and offers to take us to the High Court and look after us, Mr Kerrigan style. So this bill makes it more possible for our everyday Joe and Joanne to get the access to justice that they deserve. So I thank the Attorney-General for her hard work in relation to this important bill. The government has made and will continue to make significant reforms in areas which affect everyday Victorians. And whether it be in regard to regulations to protect workers from silicosis or... no, I don't need a glass of water, Acting Speaker, thank you. You've lost me now. Thank you. So we want to stamp out wage theft as well. So we will use all avenues to support and protect our workers and consumers, including updating our class action laws that we're here to do today. And I'd also like to thank our previous Attorney-General for his work in asking the Victorian Law Reform Commission to inquire into the access to the law in regard to class actions. And that request for that review, which was commenced in 2016, has set us down a path which has brought us here to this bill today. In amending the Supreme Court Act of 1986, which, by the way, is a very good year, and my old Jag that is gone now was an 86 Series 3, very nice car, I miss it very much. But this bill gives rise to Recommendation 8 of the Victorian Law Reform Commission's Access to Justice, Litigation Funding and Group Proceedings Report of March 2018. There's a mouthful. While I'm on that, a quick note of thanks to the lifelong service of the late Honourable Philip Cummins AN, who was chair of the Commission at the time. His distinguished career over 6 decades saw him serve as a judge of the Supreme Court of Victoria for 21 years, and it's the same Supreme Court that this bill will affect. He contributed not only to this legislation, but greatly to our legal system, and was a great advocate for victim rights. This bill will improve access to justice for Victorians by making it possible for class actions to proceed where they would be prevented because of the financial risks to plaintiffs in legal costs. The Commission found that in Victoria, class actions are underutilised. I think I heard from other members the figure of 5 a year on average. And for a class action to proceed, there must be a lead or representative plaintiff on behalf of a group of claimants. The real risk to that lead plaintiff is that if the matter is unsuccessful, they're sort of left holding the bag. And most of these cases are David versus Goliath cases. Telcos, banks, insurance companies who are very well lawyered up, and that is their right, that is the process, that's the legal system we have. But it means that if cases are unsuccessful, the everyday Joe Blow can lose it all. Lose a home, lose whatever he's got. And that's not just affecting him, that's affecting his family. When we think about cases of silicosis, that person may already be, have a life-altering malady inflicted on them. So I think this bill giving access to justice to these people makes sense. The Law Reform Commission found that if lawyers could charge a percentage amount of a potential settlement, whilst at the same time indemnifying that lead plaintiff for the other side's cost, this will lower the risk for the plaintiff. And therefore, more cases would likely to go ahead where otherwise they would not because of that financial potential burden. This bill achieves this by providing the ability for the Supreme Court to make group costs orders. It's worth restating that the lawyers for the plaintiffs would have to indemnify that plaintiff for any adverse costs in order for the group cost orders to be granted. The court can also order those same lawyers to provide security for those said costs. So the court is instrumental in this process. In practice, a representative or lead plaintiff in a class action may apply to the Supreme Court for a group costs order. The court may then choose to grant such an order, which would affect in the plaintiff's lawyers receiving a percentage of any recovered amount. Now, the Supreme Court has a very important role, as I said, in providing the checks and balances, and these orders are subject to the court's strict supervision. This bill does not tell the court exactly how to make those decisions. It doesn't tell them how much to choose the percentage. That is well within the jurisdiction of that court to decide, and that's the right place. It shouldn't be politicians making that, it should be our Supreme Court justices. So, therefore, this adds further protection for class members and safeguarding fairness of any group cost orders. It's worthy of note also that the court can adjust the percentages at any time within the proceedings. Now, there are several reasons why this bill will benefit class members, but key to the intent of this bill is to remove any financial barrier to commencing a class action for smaller and lower value claims. In our current system, these can be uneconomic to run, but potentially more likely to be run on a group costs order basis. The court is also able to improve transparency within this process for class members, and arrangements should therefore be fairly simple for the members to understand. Now, percentage-based fees are currently banned under the legal profession uniform law. However, this bill is not inconsistent with this uniform law because there's no prohibition on the Supreme Court from making a group cost order. I think it's worth saying that we don't necessarily want to take ourselves to an American free-for-all system where we have 10-metre high billboards for personal injury lawyers. That's not what this bill is trying to do. This bill is trying to give the access to justice for the everyday bloke. And so it only recommends, the bill implements one recommendation from the Victorian Law Reform Commission's Access to Justice. The government is considering the remaining 13 recommendations which were directed and will consult with relevant stakeholders. And should further legislative amendment be required, well then they will be introduced at a later time. It's worth noting that in the recommendation we're addressing today, the Commission stated that the approval of any common fund or group cost orders should be subject to conditions that are set out in legislation, as we bring today, or the Supreme Court's practice notes on class actions. Now, most of the Commission's recommendations directed to the Supreme Court on those class practice notes, and the Court is currently working on amendments of them, as is right. I commend the bill to the House.
Thank you.